A very good evening, everyone, and welcome to the session on where we examine some of the provisions which have been proposed to be included in the Competition Act. Let me share the slides first. Right. So, as we all understand, the backdrop of Competition Amendment Bill 2022, it has been introduced. It was introduced in the Lok Sabha on the 5th of August this year, and then it was referred to the Standing Committee on the 17th of August 2022. The backdrop is simple in the sense a couple of years back in 2019, the Competition Law Review Committee submitted its report, which suggested multiple substantive and procedural changes within the Antitrust Law of India. Now, the mandate of the CLRC was to draw from past experiences of the Competition Commission of India and also prepare, say, for example, for future challenges. As we understand that the market that we face is dynamic, is changing on a day-to-day basis. New technology, new types of markets have been developing, and thereby it is important that the regulator is strengthened in that sense and to handle the upcoming situations of the market. So if I quote from the CLRC, the mandate was to ensure that the Act is in sync with the needs of strong economic fundamentals. So some of the major recommendations of the CLRC pertain to the regulatory architecture of the Competition Commission of India. For example, we will see later in the discussion that there has been a proposal where the bill proposes to adopt an integrated agency model where they want to integrate the office of the DG, the Director General, with the Competition Commission of India, which is a change from the previous structure of the regulator. So that is one example. So there, in the CLRC, there were changes that were proposed in the regulatory architecture. There were changes proposed in the functioning of the CCI. And obviously, there were substantive recommendations made with respect to provisions in anti-competitive agreement, that is Section 3, abuse of dominance, that is Section 4, and your combination provision, that is your Section 5 and 6. Suggestions were also made with respect to your advocacy functions of the Competition Commission of India. And interestingly, there was also a chapter on tech or new age markets for the Competition Commission of India to be looking at. So in that backdrop, the CLRC submitted its report in 2019, post which many of the recommendations of the CLRC have been now incorporated in the Competition Amendment Bill, which has now been referred to the Standing Committee, and we'll see how many changes finally finally gets adopted in the Competition Act. So bottom line, the Act remains the same. However, there have been changes and some major changes that have been proposed within the law. So I will go on with the first categorization of amendments that have been proposed, and that is within your the provision of anti-competitive agreements. As we all understand, Section 3 handles two types of agreement. And if you look at Section 3, subsection 3, it talks about horizontal agreements, including cartels. And Section 3, subsection 4 talks about vertical agreements. In many cases, for example, if you look at the history of CCI, CCI has found that the section restricted to horizontal and vertical agreements, and thereby in many occasions CCI had to use the generality of Section 3, subsection 1 to handle situations where the agreements or arrangements did not fall into the category of either horizontal or vertical. and sometimes, especially in the trade association cases, where CCI had to penalize some of the involved entities, which though not involved in the horizontal or vertical fashion, had to use Section 3, subsection 1 for that. Now, one of the changes, say for example, which has been introduced in Section 3, that there has been a proviso that has been added, and this is the first part that I mentioned in the slide, that is hub and spoke, which also it's I'll come to that. What does that mean? But the proviso is this: that the enterprise or association of enterprise, though not engaged in identical or similar trade, shall also be presumed to be part of the agreement if it actively participates in the furtherance of such agreement. So there is a recommendation for to include a proviso after Section 3, subsection 3, and it will mostly cover, as has been popularly called, although the term has not been used in the proviso, it will cover something that is we consider as hub and spoke. Now, if you can see the slide, I have given, I've used a pictorial representation to depict how a hub and spoke arrangement function, where hub acts as a coordinator of collusive action between the spokes. So there are multiple agreements between each of the spoke and the hub, say for example, and it acts as a facilitator. It acts as a coordinator for the collusive action to go on between the spokes. Now, in such situations, say for example, hub communicates with one or more spokes and causes the sharing of information. Now, in ordinary situation, if we go beyond, if we look before the amendment that was proposed, this arrangement used to escape liability because you would not find evidence, say for example, in terms of a direct agreement between the spokes, and thereby this specific proviso that has been attempted to be added will handle that situation where the enterprise or association in question, although not engaged in identical or similar trade with the spokes, shall also be presumed to be part of the agreement. The condition is that it actively participates in the furtherance of such collusive action. Now, it is not that the CCI has not faced with allegations of hub and spoke in the past. For example, you had the Hyundai Motors case or the Snapdeal case, for example, where although there was an allegation made for hub and spoke, but the CCI concentrated on the resale price maintenance angle of the case. In 2018, for example, in the Uber case, the CCI did in fact elaborated on the circumstances, the traditional circumstances for hub and spoke cartel. And it said there are two things that are necessary. Number one is that the spokes must use a third party platform, or in other words, hub, to share information. And there is a conspiracy for collusive action. So all I'm saying is it's not that hub and spoke arrangement has not come to SEBI in terms of its assessment, although we have not seen a final order on hub and spoke, and this proviso will make it much easier for the CCI to handle those situations. If we compare, say, for example, some of the other jurisdictions in US, the hub and spoke cartels are subject to the per se analysis, or there is no requirement to prove the element of knowledge or intention. In UK, for instance, the courts look at whether the entity is intentionally engaged in a collusive conduct. So something that what we follow in UK is something that is called the concerted practice evidence, which has to be established between the spokes. While in US, what we follow is something that is called the inference standard, which presumes an agreement between spokes by considering circumstantial evidence to support absence of direct exchange between the spokes that is concerned. Uh, the point which I'm making is bottom line is one of the first change that has been brought or proposed to be introduced in section 3 subsection 3 is to provide such proviso which enables the commission to look at hub and spoke arrangements in a more efficient manner. The second change that has been brought, and we'll take up the questions at the end, obviously, the second change that has been brought is with respect to your enhancement of the scope of section 3 subsection 4. And if you look at the bill, say for example, it uses the term any other in quotes any other agreement within section 3 subsection 4, and thereby covering agreements which remain outside the domain of strictly horizontal or vertical agreements. If you remember, say for example, and this is what I was mentioning in the beginning, that sometimes CCI did face difficulty in terms of applying section 3 because the agreements in question did not fall into your specific horizontal or vertical nature. Hiranandani case comes into mind, where the agreement between the hospital and the stem cell was in question, and it was neither a horizontal or a vertical agreement, and thereby analysis under section 3 became difficult. And thereby what I'm trying to say is bottom line is, now that it increases or enhances the scope by bringing any other agreement, it will help the CCI again in analyzing agreements which do not technically fall within the angle of horizontal or vertical agreements. It may also be relevant in future for digital markets where these kind of agreements or different types of agreements are entered into by service providers. The third change, and I'll move quickly. The third change which has been introduced with vis-a-vis section 3 is something that we have known all along. CCI in the very beginning, I think it was one of the earlier cases in 2011 where CCI was dealing with a case with respect to DTH, where CCI made it clear that what we assess under agreement, say for example, is not the agreement between the manufacturer or and the end consumer. So what has been done is that there has been a proviso, which I think it's more of a clarification or a reassertion of the previous point, that we will not assess, since agreement between the manufacturer or the service provider and the consumer and the end consumer does not fall within the parameters of your manufacturing or distribution chain. The agreement with the end consumer will remain outside the assessment of section 3. So this proviso that has been added obviously is more of a clarification. However, two major amendments that have been proposed. One is with respect to the hub and spoke, where a proviso has been added to include such agreements, where the CCI will have to prove that there has been a collusion which has been coordinated by the hub. And then there's also an enhancement of the scope of section 3.4 to enable the CCI to handle agreements outside the strict domains of categorization done in section 3. When we move forward within the abuse of dominance, let me invite Gautam Shahi sir in terms of explaining the changes that have been introduced or proposed to be introduced within section 4, 5, and 6, which are substantive provisions again of the Competition Act.
Thanks, Sudhanshu. Okay, so one of the major changes as far as section 4 goes, and I think it's relevant for section 5 also, is with respect to the definition of relevant market. Now, as we know, definition of relevant market is one of the fundamental instruments of any competition regulator. So if you want to assess who is the big guy, who is the dominant player in the market, you define the market first and then decide, see who is the biggest player based on either the market share or his access to capital, all those elements. So defining the relevant market is one of the fundamental things that you do with respect to abuse of dominant, with prosecuting a case of abuse of dominant position, or whether it be assessment of combinations. And now, as Supreme Court has said, even in case of Section 3, CCI may define the relevant market to assess the adverse effect of any kind of conduct and any kind of agreement in the market. Now, traditionally, in all jurisdictions globally, when we define relevant market, it's based on demand side substitutability. So it's from a consumer perspective, what are the products which can be treated as substitutable? Simply put, if you look at refreshing drinks, then maybe you can question whether tea and coffee are substitutes or not, or maybe even a glass of water is a substitute of tea or not, because all of them can refresh you. So demand side substitutability, that is how the consumers consider different products to be substitutes, was an important factor for defining the relevant product market. That these are the products which are imposing competitive constraint on each other. However, with the proposed amendment, they want to involve or include an element of supply side substitutability while assessing both the relevant product market and relevant geographic market. This is an issue which I find a little problematic. That may raise some concerns. So if we look at global practices in Europe, they do consider supply side substitution, but only if it supports your conclusions on the basis of demand side substitutability. So it cannot be an independent factor for assessing the demand side, for assessing the relevant product market. In UK, they desist from using this factor unless it is absolutely relevant. And in US, they don't use this factor at all. They don't consider supply side substitutability as a factor for defining the relevant market, either product market or geographic market. However, when we include this particular factor in the list of factors that CCI must consider while defining the relevant market, it may lead to some unwanted results. And how? Now, in a matter that happens in future, and if these amendments go through, one can always counter the definition of relevant product market based on the assessment of supply side substitutability. I'm sorry, I missed. I should explain what supply side substitutability is. It basically means whether the suppliers of a particular product with a little bit of expense and a little bit of time shift to producing an alternate product. So the primary product that they were manufacturing and the product to which they have shifted to both become part of the same relevant market. This can be seen in a product like paper. You have papers of various thickness which are used for different purposes. You have bond paper, you have normal printing paper, you have photocopying paper, you have paper which is used for making your cups. So the different kinds of papers which are made using the same machinery. So minor changes in the machinery, minor changes in the raw material, and you can start producing an alternate kind of paper. That's where a supply side substitutability comes into being. However, like I said, globally and traditionally is the demand side substitutability which is considered a primary factor. The amendment tries to bring in supply side substitutability at the same level, or at least on a similar level as demand side substitutability, which I feel may not yield desirable results. So that's one. Second is something that Sudhanshu and I have been discussing on whether Section 4 assessment, abuse of dominance, should also include an assessment of an adverse effect on the market to decide whether or not the conduct amounts to an abuse. If you look at Section 3 very clearly, Section 3 says an anti-competitive agreement which causes appreciable adverse effect on the market. So that there is an assessment of appreciable adverse effect in the market before you conclude whether or not a particular conduct is anti-competitive. And this is something that should be discussed widely in the academic circles and by practitioners on whether or not an effect-based assessment is required in case of a Section 4 case, that is abuse of dominant position case as well. So, Ashu, you want to move to the next slide? Now, coming to combinations, we have seen combination provisions were notified in 2011. Initially, there was a lot of concern in the industry about having a new regulator assessing all the M&A activities. And it was after a lot of discussion and a lot of convincing that finally the provisions related to combinations were notified in 2011. And we have seen a lot of growth in our understanding of combinations in India. CCI has become more confident about assessing these transactions. And what we see is now a result or as a result of learnings over a period of the last 10 years. 12 years, 10, 12 years, yeah. So you look at control, and we have seen that CCI has tried to, over a period of, during the precedents, we have seen the CCI has said, look, we are going to have expansive definition with respect to control. And control is an important element while assessing transactions which require approval of the CCI. And generally, we'll find in different provisions and combinations, if there is a shift of control happening, whether that happens by virtue of acquisition of shares or by transfer of technology or other element, if there is a shift in control happening, that is when CCI says, I want to look at a particular transaction. Hence, the definition of control is very important. So CCI has said, I want to give an expansive definition, and they have been saying that negative control, positive control, all these are elements of control that they will consider. Even if you have a director over a company in the board of a company, I will consider that as control. Now, what CCI has done is, to put it simply, in the proposed amendments, they have said, look, when we define control, we'll also consider material influence. And as you know, material influence is such a vague word, it can be interpreted very widely. So any kind of material influence will also be considered while assessing whether or not an entity or a person has control over other entity or a person. Next is the element of open market acquisitions. Now, CCI has seen over a period of time that in certain, you see, we have a standstill obligation in India. So you can't execute a transaction unless you get the approval of the commission. You may sign an agreement, but you can't execute the transaction. Now, CCI has realized that over a period of time, that in certain transactions, certain steps need to be taken. It is important. Hence, in certain cases, and these are the two cases that CCI has specified, the CCI has done away with the standstill obligation. One is an open offer. Second is an acquisition of shares or securities through a series of transactions on a regulated stock exchange. So in both these cases, CCI has done away, or rather they proposed that the standstill obligation be done away with, and parties can go ahead with those transactions, with those steps. Of course, all these steps are dependent on the final approval of the transaction by the commission. But these steps will not lead to a case of gun jumping. Parties would not be penalized. There has been now, coming to the next amendment, there is a significant change in the timeline for review. They have been cut down drastically. Most of the timeline has been cut down by 50%. It's a very welcome move. I'm sure industry would love it. But one concern is that does the CCI have the requisite manpower to achieve these timelines? Since the establishment of the commission, and then especially the notification of the relevant provision in 2009, CCI has always faced a crunch of trained resources. Now, with further reduced timelines, do they have access to the requisite resources, requisite manpower to achieve these targets? That's something that CCI needs to consider, government needs to consider, and if they implement these provisions, they should make provisions for additional human resources at the commission. Next is deal value threshold. As of now, there are thresholds based on assets and turnover. Simple. But what was happening was, in many cases, those parties with maybe lesser assets or lesser turnover uh, got away from a requirement of filing before CCI. Those were not subjected to the review of the commission. So now the proposed amendment, they want to include a deal value threshold, and that's some 2,000 crores. So any deal which is above 2,000 crores has to go to the commission. The second limb of this requirement is that the party should have substantial presence in India. What is substantial presence in India has not been defined. That is something that has been left to CCI to define through the regulations. So what this will ensure is, even transactions happening globally, even if the parties are smaller, if the value of the deal is high enough, and if the parties have substantial presence in India, they need to come and take the prior approval of the commission, which I think is a good thing. However, if you see recently, one noticed that when PVR acquired Inox, and there was this whole noise about why this is not being subjected to CCI scrutiny. In fact, somebody even filed a case before CCI and asked them to look into it. And CCI said, look, the thresholds are not being met. Hence, we can't look at this particular transaction. Now, in that particular transaction, why it was not notified was because of the target exemption. We have this target exemption, small target exemption or de minimis exemption, whereby if the turnover is less than 1,000 crores and the assets of the target is less than 350 crores, then in that case, they don't need to go to the commission. Now, if we implement the deal value threshold, there'll be a requirement of a corresponding change in the de minimis exemption as well. So we'll have to see how those issues are tackled. So on to next slide. I think this is yours.
I'll take up this, and then you can come back with settlement and commitments.
Sure.
Two other major things. See, we are only trying to highlight some of the major changes that have been proposed. Obviously, there are certain cosmetic changes that have been introduced otherwise in the Competition Act with respect to definitions, with respect to procedural powers of the Commission. One of the changes that is worth mentioning is the integration of the office of DG with the CCI, and this also comes in the backdrop of the recommendation of the Competition Law Review Committee report in 2019. If you all remember, Section 16 did talk about the central government appointing the Director General to assist the Competition Commission of India in conducting the inquiry. Now, the 2022 bill, proposes to empower CCI to appoint the DG. The DG will be directly accountable to the Commission. The CCI will control the appointment, appraisal, and even the HR matters of the Director General's office. Now, it has been said that it is in tune with other domestic sectoral regulators like SEBI, and also in tune with some of the other jurisdictions, other comparable jurisdictions for that matter. The CNRC was of the opinion of the committee. If you look at the committee report, it mentioned that the CCI was in fact already monitoring all activities of the DG's office. So, in all practical purposes, we have only recommended the integration, which was on practical reasons, CCI was already doing it. So, in integrating the DG's office with the CCI, theoretically, what they have adopted is the integrated agency model for the competition regulator. This is similar to some of the jurisdictions like US and EU. Now, The concern that I want to raise basically is with respect to something that was highlighted by the working committee, not the final report, but the working committee in the law competition law review committee. That and if you download that document, there's an entire paragraph where it says it may lead to concerns of confirmation bias. Where, if you remember, if you look at the entire structure of the Competition Act, uh, any information that is filed under Section 19 of the Competition Act, the CCI forms a prima facie opinion. And if the CCI forms a prima facie opinion that there is some matter within the information that has been filed, it directs the DG to conduct an investigation. So order is passed under 26(1), for which after which DG conducts an investigation. However, if the CCI feels that there is no matter in the information, it may close the matter under 26(2). However, when it orders the DG to conduct an investigation, the working group was of the concern that it should not lead to, when the CCI so DG is integrated with the CCI, it should not lead to a loss of independence of the DG's office. Now, integrating DG's office with the CCI may lead to a situation where the DG's office may want to conform to the opinion of the CCI. So if CCI says conduct an investigation, it may it may, in the sense, have some influence on the DG performing its activities in terms of conducting the investigation more objectively. So it has to be seen, it has to be assessed later, and the CCI has to be careful that objectivity is maintained in the processes that has been established within the Competition Act. So when the CCI orders an investigation, DG should not be pressurized in terms of conforming to the opinion of the CCI, conduct an independent and objective investigation, submit the investigation report to the CCI, for the CCI to then consider the merits or the evidences which has been produced by DG in terms of finalizing of the matter of whether there is a violation of competition law or not. So it is still early days in terms of raising this concern, but there have been concerns raised in other parts of the world in terms of adopting this model, where it may affect the objectivity of the functioning of the Director General's office. So that is one point. The second, with respect to your one of the major changes that has been brought in terms of enforcement, is settlements and commitments, which Gautam sir will take up.
Thanks, Sudhanshu. Before I take settlement commitment, there's something that I want to talk about: integration of DG with CCI.
Right.
You see, and we have discussed this before, that there are two elements. One is that competition law is not an island by itself. It is supposed to operate under the Indian legal system. In the Indian legal system, it has always been a fundamental principle that a judge and a prosecutor cannot be the same. Now, you see, DG to an extent is playing the role of prosecutor. This may be debated, but in my view, to an extent, he is playing the role of a prosecutor. And CCI is judging the whole issue. So if you integrate these two offices, the outcome may not be good. Especially, which this brings me to my second point. In a culture like India, I am reminded that there was a case study done in Japan where there were a lot of flights crashing. And when they did a study, they realized the crashes were happening because the second officer, the junior officer, junior pilot, was not inclined to contradict or correct the captain who was his senior. There's a similar culture in India where there's a lot of respect and regard given to your seniors. Now, in a culture like this, if you integrate these two offices, the independence of the DG may get severely constrained. And that's something to be thought about before they implement the system. So I don't think it's a good idea for CCI to be made responsible for appointing the DG. Now, coming to the issue of settlement and commitments, uh, let me explain what a settlement and commitment is uh, in the West. It's a common concept there. It's a new thing in India. And that's my first grievance with the statute, because the term settlement and commitments have not been defined. Now, in case of settlement, there is an acceptance of guilt. So a party says, yes, I made a mistake. And let's, instead of fighting out this case, you impose certain penalty on me and let me go. Okay, some reduced penalty. That's settlement. And the settlement is a case which is a precedent. You treat it as a precedent that this conduct was considered to be anti-competitive and hence the party was penalized. However, in view of the settlement, there was a reduced penalty. In case of commitments, there is no acceptance of guilt. The party says, yes, I'm under investigation. I don't accept that I have violated the provisions of the competition law. However, if you have some concerns, if the commission has some concerns, here are my commitments which will address the concerns of the commission. Those commitments may be in terms of conduct, that I will not behave in a particular manner. So I address your concerns and you let me go. I think ideally these should have been defined in the statute itself if the provisions are being made. Nonetheless, let's go ahead with this. This is a welcome provision. I think it will save a lot of legal costs for the parties. It will save a lot of legal time and cost for the commission, which, the kind of time and money which is spent by the commission in prosecuting anti-competitive conduct. That will be saved if parties start going in for settlements and commitments. A bigger issue is that this commitment and settlement system is based on discussions between parties and the commission. However, there is a third party in this whole case who has been ignored. That is the victim of an anti-competitive conduct. The statute, the proposed amendments provide that in case there is a settlement commitment which happens, then there is no appeal possible. Now, if a victim is there of an anti-competitive conduct, till now he had access to the appellate tribunal to go and seek damages. What happens to him now? Can he, after a settlement commitment has been reached by the commission, can a party go to the appellate tribunal and seek damages? There's a lack of clarity on that. In the West, if there is a settlement, then parties can still go ahead because there is acceptance of guilt, then a victim can go and seek damages. Commitments, of course, there is no acceptance of guilt, so there is no damages. There is no question damages being given. But there's a lack of clarity in the proposed amendments on how this issue would be tackled. If I have suffered as a result of an anti-competitive conduct of a particular entity, and that entity has a settlement or a commitment with the commission, do I have a right to go and challenge it, or rather, do I have the right to go to appellate tribunal and seek damages based on this? That's something that should be addressed in the amendments. Sudhanshu?
So, in addition to what we have presented here in terms of the larger recommendations with respect to competition amendment bill, you will find in the competition bill provisions which has expanded the powers of DG. For example, DG will have enhanced search and seizure powers. Will also have the power to summon and examine agents of the company, that is, any person acting or on behalf of the company, potentially including its third-party agents, say for that matter. Then you have provisions for limiting the scope of repetitive information references. So there are other minor recommendations that have been made. We have tried to present some of the major recommendations within the bill, and we'll have to wait and watch as how many of those recommendations get finally adopted. So I'll stop sharing now, and we would ask Rachit to invite questions.
Dear participants, if you have any questions, you may just post on the chat box. So far, we don't have any queries from the participants.
Right.
Dear participants, if you have any questions, please post in the chat box.
I see a raised hand by Piyush.
I think there are no questions, so we can conclude the session. Thank you so much, Dr. Mr. Gautam Shahi, and
I think something has come, Rachit.
there was, yes, one question is from Parmeet Gupta ji. So he has asked, sir, was there any judicial opinion regarding the hubs and spoke agreement before this amendment?
No, so as I said, there have been allegations. So, for example, if you remember the Olas and the Uber cases, there have been allegations made with respect to the algorithmic coordinated collusion, where the algorithm, and this is one of the major things that will come up in future with respect to creation of algorithm, which may coordinate prices between the service providers. So in the Ola or Uber case, say for example, it was alleged that there is a collusion between drivers in terms of prices that they charge from the service providers. So I said in the beginning that there have been cases, for example, Hyundai Motors or Snapdeal or say Uber case in 2018, where there have been allegations made. But I do not think that there has been a case where CCI has finally decided on the exact component of hub and spoke.
Yes, apart from this, any other queries, dear participants, please, you may ask, you may write down it on the chat box. Yes, we have one more query from Shweta Nimwal. She is asking, does change in regulations of open market purchases right for the market?
I'm not sure what that question is. As in, if this is a good move. If that is the question, then yes, it is a positive move, because when we used to do these filings in these kind of circumstances, uh, having a standstill provision created a problem. Okay, that's when we had to rush to the commission, request for immediate approval so that we can take the steps required for these kind of transactions before the securities regulator. Doing away with this standstill requirement for such transactions is a positive move. And yes, for these, especially for these kind of transactions, a good thing. I hope that makes sense, Shweta.
Yeah.
Rachit, are you there?
Yes. So participants, any further queries? You may please post it. Yes, one more query from Navodaya. Can big data be included in the deal value for M&A deal?
I mean, and what do you mean by that, Navodaya? Do you mean that big data as a value of big data? Can it be included in the deal value of M&A? Well, if I am buying out a company which has a lot of big data, I am sure there's an element of consideration that is there. So that's why the moment you consider deal value, that means from a market perspective, what is the value of the target company? And if it is about 2,000 crores, I'm sure the buyer is considering big data, which is the kind of data which is there in the target entity. If you look at the recent example, the value of Twitter is high because the kind of data that it has for its for its consumers. So yes, I think big data is already a part of that process. The moment you consider deal value, we consider deal value for assessing the filing requirement. Big data becomes a part of it.
Okay, there's a comment from Mr. Rahul Jain. He's saying that the query about the other panelists, other participants, whether the commission should consider big data as a factor in assessing dominance or market power.
According to me, yes. So while I think now this question was specific to M&A, but even with respect to dominance, I would say big data is something that needs to be considered, because today access to data really influences the kind of market power that you have. And if you look at companies like Facebook or Google, the kind of data that they have, the kind of extra big data that they have, really improves their market power. It improves the market power in terms of targeted advertisements that can be offered. So yes, or even targeted the kind of product that you want to offer to a particular consumer and all that. So yes, big data, according to me, is a factor which should be considered while assessing the dominance market power of entities.
Okay, any other query panel participants? Okay, further, in addition to the previous question, and what about the aspect of privacy? Do you think the commission should look into it, or we need a separate data protection authority?
So if you look at the ongoing litigation against WhatsApp, Commission is already looking at privacy issues. Okay. Commission is looking at privacy issue from abuse or dominance perspective, as in, are you putting conditions with respect to privacy issues which are in the nature of an abusive conduct by a dominant player? So as far as privacy issues with respect to a dominant player are concerned, Commission can look into it. But what if a non-dominant entity starts trying to impose conditions which may be violating privacy of the consumers? That is something that CCI cannot look at. Hence, I believe there should be a data protection authority that is required, because CCI cannot address all the aspects which are going to arise with respect to data privacy, with respect to privacy.
And the responsibility of a dominant player has always been stressed by the Competition Commission of India. And thereby, if there is any provision, any clause which has been introduced by a dominant entity, which seems to be unfair, and it will be assessed by the Competition Commission in terms of Section 4, vis-a-vis abuse of dominance.
So this will be a classical case of a overlap between two authorities. If you have a data protection authority, of course, they'll be looking at it under their specific law. And as well as data privacy issues are concerned, or an abusive conduct is considered concerned with respect to data privacy, then Commission will also have jurisdiction to look at those.
So yeah, so I was thinking, so if you have Section 4, which talks about abuse in the form of directly or indirectly putting unfair conditions in the sale of service. So if you put in a conditions which is unfair, which as a consequence probably leads to violation of privacy, then I'm drawing a long conclusion in terms of putting that as an abuse in itself.
I agree. My only concern is, Sudhanshu, that what if it is done by somebody who is not a dominant player?
Right.
For situations like that, you need to have a data protection authority.
Right.
What if 5 non-dominant players impose the same condition?
See, again, the question is, but don't you think only a dominant entity is in a position to hamper the privacy of consumers without affecting its consumer base, considering which the Commission has to jump in every time? See, yes, Section 4 does talk about abuse of a dominant entity. So it will be necessary to see whether the entity is dominant or not. But we have seen in the last few years, we have seen many sectors where there are multiple service providers, and these service providers have been able to impose unfair conditions in their service, which the consumers more or less have agreed upon without much questioning. So whether in terms of social media, whether in terms of your online platforms for markets, say for that matter, you do not have one player which is dominant. And although, say, for example, in those situations, the CCI will find it difficult to proceed under Section 4 because the first condition is to establish dominance. Probably privacy will be looked at from more of a sectoral regulator in that situation.
That does remind me, Sudhanshu, that the concept of collective dominance has still not been read into the Act.
No.
Even in the proposed amendments.
Yeah, collective dominance does not find a place.
That should have been included.